Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 6th February 2025 and we bring you news that matters. The first news for today is as follows. In a recent ruling, the Supreme Court of India emphasized that omitting certain accused individuals from a first information report (FIR) can be a significant factor under Section 11 of the Indian Evidence Act. The court noted that a witness to a crime would typically identify all perpetrators in the FIR. Therefore, selectively naming some while excluding others is considered unnatural and undermines the credibility of the complainant's account. This omission, though otherwise irrelevant, becomes pertinent under Section 11 of the Evidence Act. The bench comprising Justices J.B. Pardiwala and R. Mahadevan upheld the acquittal of an individual in a murder case, highlighting that the complainant, who was the deceased's father, failed to mention two alleged perpetrators in the FIR. Despite claiming to have witnessed the crime, the complainant only identified one of the three assailants. The court observed that such an omission is significant and relevant under Section 11 of the Evidence Act. This decision underscores the importance of comprehensive and accurate reporting in FIRs, as omissions can influence the evaluation evidence and the outcome of criminal proceedings. Next news. The Nagpur High Court has issued notices to several banks in response to a petition filed by Vijay Mallya, the fugitive businessman and former chairman of United Breweries Holdings Limited (UBHL). Mallya seeks detailed statements of accounts concerning the amounts he, UBHL, and other associated entities owe to these financial institutions. Resenting Mallya, senior advocate Sajan Poovaiah informed the court that both Kingfisher Airlines and UBHL have been ordered to wind up, with these decisions upheld up to the Supreme Court. He asserted that the debts in question have been recovered multiple times over. Specifically, Poovaiah highlighted that while the Debt Recovery Tribunal mandated a payment of 6,200 rupees, crore recoveries have exceeded this amount, with official statements indicating recoveries of 10,200 rupees crore and even 14,000 rupees crore, as noted by the finance minister in Parliament. The petition emphasizes that if the debts have indeed been fully settled, UBHL, as a guarantor company, should no longer bear any liability, and could potentially be revived. However, such a revival is contingent upon the issuance of a certificate from the recovery officer confirming the full repayment of the debt. To date, no such certificate has been issued, and recovery actions continue. The court has scheduled the next hearing for February 13, during which the banks are expected to respond to the notice. Next news. The Supreme Court of India has clarified that applications seeking exemption from surrendering are admissible only when the petitioner has been sentenced to a term of imprisonment. This interpretation aligns with Order 2-2 Rule 5 of the Supreme Court Rules, 2013, which specifies that such applications are pertinent solely in cases where the appellant has received a custodial sentence. The court observed that its registry has been accepting applications for exemption from surrendering in various other scenarios, such as the rejection of anticipatory bail or requests for extension of interim bail. The bench, comprising Justices Vikram Nath and Sandeep Mehta, emphasized that such applications should not be entertained in these contexts. This clarification came during the hearing of a case where the Gujarat High Court had declined to extend temporary bail for a petitioner convicted of offences including murder. The petitioner filed a special leave petition accompanied by an application seeking exemption from surrendering, which was subsequently rejected by the judge in chamber. The Supreme Court noted that according to its rules, the application for exemption from surrendering should not have been entertained in this situation. This ruling underscores the court's commitment to adhering strictly to procedural rules, ensuring that applications for exemption from surrendering are considered only in appropriate circumstances. Next news. In a recent judgment, the Supreme Court of India acquitted a man previously convicted of murdering his partner, emphasizing the inherent weaknesses of extrajudicial confessions and the necessity for a complete chain of circumstantial evidence to establish guilt. The case involved the appellant, who was in a live-in relationship with the deceased. Following a quarrel, he allegedly assaulted her, leading to her death. The prosecution's case relied heavily on an extrajudicial confession made by the appellant to his landlord and the deceased's relatives. Both the trial court and the High Court convicted him based on this confession and other circumstantial evidence. Upon appeal, the Supreme Court highlighted that extrajudicial confessions are considered a weak form of evidence. The court reiterated that for a conviction based solely on circumstantial evidence, all circumstances must be proven beyond reasonable doubt, closely connected the she principal fact and form a complete chain pointing unequivocally to the guilt of the accused. Any gap or inconsistency should favor the accused. In this instance, the court found that the appellant was in a confused state of mind when making the confession, casting doubt on its voluntariness and reliability. Additionally, the absence of corroborative evidence, such as the recovery of the murder weapon, weakened the prosecution's case. Consequently, the Supreme Court acquitted the appellant, underscoring the principle that suspicion, no matter how strong, cannot replace the necessity of proof beyond reasonable doubt in criminal convictions. Next news. In a significant ruling, the Supreme Court of India has determined that a woman can claim maintenance under Section 125 of the Criminal Procedure Code, CRPC, from her second husband, even if her first marriage was not legally dissolved. The court emphasized that a formal divorce decree is not mandatory when the woman and her first husband have mutually agreed to separate. This absence of legal dissolution does not prevent her from seeking maintenance from her second husband. The bench, comprising Justices B.V. Nagaratna and Satish Chandra Sharma, granted relief to a woman whose maintenance claim had been denied by the Telangana High Court. The High Court had previously ruled against her on the grounds that her marriage to her first husband was still legally valid. The Supreme Court overturned this decision, highlighting that the right to maintenance under Section 125 CRPC is both a legal and moral duty owed by the husband. The court further noted that this provision should be interpreted broadly, considering its social welfare objective. This judgment underscores the court's commitment to ensuring social justice and acknowledges the complexities of marital relationships, affirming that mutual separation without formal divorce does not disqualify a woman from claiming maintenance from a subsequent marriage. Next news. In a recent judgment, the Supreme Court of India emphasized the necessity for meticulous examination in cases where the first information report, FIR, is lodged against unknown individuals, and the accused are not previously known to the witnesses. The court highlighted that in such scenarios the evidence collected during the investigation is crucial in determining the credibility of the case against the accused. The bench, comprising Justices P.S. Narasimha and Manoj Misra, outlined key aspects that courts must scrutinize in these situations: derivation of clues, how the investigating agency identified the involvement of the accused in the crime, arrest procedure, the manner in which the accused was apprehended, identification process, the method by which the accused was identified by witnesses. This ruling came in the context of a case involving a bus robbery where the appellants were unknown to the witnesses prior to the incident. The prosecution's case relied heavily on the testimony of a witness, who claimed to have recognized the accused near a bus depot 2 days after the crime. The Supreme Court found significant flaws in the investigation, particularly concerning the identification process, and subsequently overturned the conviction of the accused. The court underscored that mere assertions by the prosecution are insufficient. It is imperative to establish who committed the crime through reliable and thoroughly examined evidence. This judgment reinforces the importance of diligent judicial scrutiny in cases involving unidentified perpetrators to prevent wrongful convictions. Next news. In a recent judgment, the Kerala High Court emphasized the need for extreme caution when comparing signatures based solely on photocopies, especially in the absence of original documents. The court described this practice as a slippery slope and highlighted the potential unreliability of such comparisons. The case involved a lawyer who had extended a loan of 45 lakhs to the managing director of a hospital. When the loan remained unpaid, the lawyer filed a suit for recovery, leading to a conditional attachment of the hospital's property. The defendants contended that the amount was not a loan but an advance payment related to an agreement in which the lawyer purportedly intended to purchase the hospital. They argued that the lawyer had failed to fulfill his part of the agreement, necessitating the sale of the hospital to another party. The trial court had compared the signatures on the lawyer's suit documents with those on the alleged agreement despite only having photocopies available. Based on this comparison, the court found the signatures to be similar and ruled in favor of lifting the attachment. However, the High Court overturned this decision, underscoring the inherent risks in relying on photocopied signatures for such determinations. The High Court's ruling serves as a caution against making definitive legal conclusions without the availability of original documents, thereby reinforcing the importance of thorough and careful judicial examination in matters involving disputed signatures. Next news. In a recent ruling, the Delhi High Court emphasized that an arbitral award issued by an improperly appointed arbitrator is invalid and holds no legal standing. The court highlighted that if the agreed-upon procedure for appointing an arbitrator, as outlined in the contract, is not strictly followed, any resulting arbitration proceedings are considered non-est or non-existent in the eyes of the law. The case involved a dispute where petitioner challenged the appointment of an arbitrator, who was the general manager, business unit head of the respondent company. The petitioner argued that this individual had been directly involved in the contract as supervision and had made the decision to terminate it, leading to concerns about impartiality. Despite these objections, the respondent proceeded with the appointment as per the contract as arbitration clause. The court found that the appointment did not adhere to the agreed upon mechanism, rendering the arbitrator's jurisdiction invalid and the subsequent award void. This decision underscores the critical importance of adhering to contractual procedures in arbitration appointments. Deviation from these agreed terms can result in the nullification of arbitration proceedings and any awards granted therein. Next news. The Bombay High Court has agreed to hear a petition filed by Skoda Auto Volkswagen India challenging a $1.4 billion tax demand issued by Indian customs authorities. The hearing is scheduled for February 17. The dispute centers on allegations that the company misclassified imports of Audi, Skoda, and Volkswagen vehicles, according to the customs authorities, instead of declaring the imports as completely knocked down CKD units which are subject to a 30-35% duty. The company labeled them as individual parts, attracting a lower duty rate of 5-15%. This classification allegedly led to a significant underpayment of customs duties. In September of the previous year, a show cause notice was issued to Skoda Auto Volkswagen India under the Customs Act, accusing the company of misleading customs through its made-oath of import parts as separate units rather than as components of CKD units. This case highlights the ongoing scrutiny of import classifications and customs duty payments by multinational automotive companies operating in India. Next news. A public interest litigation, PIL, has been filed in the Bombay High Court addressing cyber attacks on official Maharashtra state government websites. The petitioner, an information technology consultant and visiting professor of law, contends that inadequate security measures and lack of monitoring have led to parts of these websites being compromised. Specifically, malicious software has redirected unsuspecting visitors to gambling sites attempting to collect personal information. Upon discovering the issue, the petitioner reported it to the Maharashtra Cyber Helpline, which declined to register the complaint, stating they only handle cases related to personal injury and financial fraud. Similar responses were received from the National Cyber Crime Helpline and the Computer Emergency Response Team of India Certain. The PIL highlights that the state's official servers lack essential security features such as a web application, firewalls, antivirus software, and intrusion detection systems. It also points out that outdated content management systems have been exploited by cybercriminals to inject malicious code. The petitioner warns that such vulnerabilities could lead to phishing attacks, fake e-challan payments, and the dissemination of counterfeit government resolutions. The petition seeks directives for the state authorities to block the infected websites, implement preventive measures against future cyber attacks, register FIRs against those responsible, and expedite the establishment of a cyber task force dedicated to securing government websites. This legal action underscores the critical need for robust cybersecurity infrastructure to protect sensitive government information and public users from malicious cyber activities. Next news. The Punjab and Haryana High Court has denied bail to a woman accused of blackmailing a 73-year-old doctor by recording and threatening to distribute an obscene video of him. The woman, along with co-accused individuals, allegedly extorted over 1.34 rupees crore from the doctor. In its ruling, the court highlighted the alarming rise of online sextortion cases, particularly following the increased use of online dating platforms during lockdowns. Thus, crimes often involve predators deceiving individuals, especially teenagers, into explicit activities over video calls, secretly recording them, and then threatening to disseminate the footage unless financial demands are met. The court emphasized that such acts are dehumanizing and exploit the victim's shame, leading to devastating emotional consequences including feelings of embarrassment, hopelessness, and isolation. The court also noted that involving minors in these schemes is a common tactic, as the Juvenile Justice Act, 2015, provides for lighter punishments for juveniles. This practice underscores the need for stringent measures to combat online sextortion and protect vulnerable individuals from such exploitation. By denying bail, the court aims to prevent interference with the ongoing investigation and to ensure that all aspects of the sextortion scheme are thoroughly uncovered. This decision underscores the judiciary's commitment to addressing the growing menace of online sextortion and safeguarding individuals from such exploitative crimes. Next news. The Supreme Court Collegium has recommended the appointment of 3 additional judges as permanent judges or the Telangana High Court. The recommended judges are A. Justice Lakshmi Narayana Alishetty, Justice Anil Kumar Jokanti, Justice Sujana Kalasikam. Thus, judges were initially appointed as additional judges on the 31st of July 2023. The Collegium's recommendation is a significant step in the judicial process, as it reflects the Collegium's assessment of the judge's performance and suitability for permanent positions. The final appointment will be made by the President of India following the Collegium's recommendation. This development underscores the ongoing efforts to strengthen the judiciary by ensuring that competent and experienced individuals are appointed to permanent positions, thereby enhancing the efficiency and effectiveness of the judicial system. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.